Hello everyone, welcome again to our channel. So this is Attorney J&J, Law Made Easy. Today we will be discussing yung last na modes ng extinguishment of obligation, which is novation. At last, makokompleto na natin ang lahat ng mga modes of extinguishment of obligation. So wag na nating patagalin pa. Let's begin. So, Article 1291. Obligations may be modified by number 1, changing their object or principal conditions. Number 2, substituting the person of the debtor. And third, subrogating a third person in the rights of the creditor. So, obviously, this provision talks about novation. Actually, pag sinabi mo namang novation, ng new obligation. And so, papaano? First, by changing the object or yung principal conditions mismo ng obligation. Second, is dun sa change naman sa person ng debtor. And third, yung sa change sa person ni creditor. Pero the right term is subrogating a third person in the rights of the creditor. So, unlike doon sa naunang mga discuss natin na modes of extinction or extinguishment of obligation, dito, si novation ay mayroong dalawang function or dual function siya. First is, yung original obligation is extinguished. Kaya nandito siya sa extinguishment of obligation. Kasi yung original obligation ay nai-extinguished. And yung second function niya is the creation ng new obligation. Okay? A new obligation is created. So, novation is the most unusual mode of extinguishing an obligation. Kasi nga, it is only the mode whereby an obligation is extinguished and a new obligation is created to take its place, right? Now, what are the kinds of novation? Meron din naman. So, first, they are classified according to origin, meron ding according to how it is constituted. Pwede rin siyang according to the extent or effect, and yung lastly is according to the subject. So, madali lang naman to. Yung first, kung sa origin, pwedeng legal, pwedeng conventional. Pabalik-balik na tayo when you say legal by operation of law, conventional by agreement of the parties. Now, kung how it is constituted, pwedeng express, pwedeng implied. Express, pag may express declaration talaga na magkakaroon ng novation. Tapos implied, pag walang express stipulations, implied lang sa conduct. Tapos, according to the extent, pwedeng total, pwedeng partial modification lang. Then, according to the subject, ito. Pwede siyang real or objective, and pwede siyang personal or subjective. And actually, meron pang mixed. So, when you say, ito, i-discuss natin. Real or objective, ito yung isang novation wherein yung object or yung principal conditions ang naiba or nagkaroon ng change as to the object or principal conditions. Kaya, objective, di ba? So, example, Pogi obliged himself to give Ganda his Toyota Vios car. Tapos later, napagkasunduan din nilang dalawa na instead of giving the Toyota Vios car, Pogi yung kanyang Fortuner na lang ang kanyang ibibigay, right? So, ang original obligation is to deliver Pogi's Toyota Vios car. Tapos, later on nga, nagkaroon ng novation at dahil ang ibibigay na lang daw is to deliver the Toyota Fortuner ni Pogi. Dito, na-extinguish yung first obligation na to deliver Pogi's Vios car. Tapos, napalitan ng Fortuner. Okay? Yung object ng kanilang original obligation was changed. So, that is real or objective. Tapos, sa personal or subjective naman, when the person of the debtor is substituted and or when a third person is subrogated in the rights of the creditor. So, ito yung second and third na dun sa Article 1291, di ba? Na enumeration, either na-change yung person ni debtor or si creditor ang napalitan. Okay? Halimbawa, Pogi owes Ganda 10,000 pesos. Tapos later on, si Pogi, si Ganda, and si Beauty agreed na ang magbabayad, na instead na magbayad si Pogi ng 10,000 pesos kay Ganda, si Beauty na daw ang magbabayad ng 10,000 pesos kay Ganda. Nag-agree sila to extinguish that previous obligation or yung original obligation, at eto na yung bagong nais, si Ganda na ang magbabayad. This is a personal novation kasi eto yung example ng substituting a third person in the person of the debtor. Okay? May bagong debtor. So, kailangan mag-agree yung lahat ng parties. Okay? Yung original obligation was extinguished, tapos nagkaroon ng new obligation. Right? So, that is personal or subjective novation. Tapos, yung last is yung mixed. When you say mixed, eto yung object or yung principal condition ng obligation and pati pa yung debtor or yung creditor are changed. So, mix ng objective tsaka subjective. So, okay, combination noong dalawa. Example, Pogi promised to deliver his Vios car to Ganda. Tapos later on, Pogi, Ganda, and Beauty agreed na instead na yung Vios car ni Pogi ang ibibigay kay Ganda, si Beauty na ang magbibigay ng kanyang Toyota Vios car kay Ganda. So, there is a mixed novation kasi yung object first, yung object na change. Instead na yung Vios car ni Pogi, yung Vios car na ni Beauty. And second, also, yung person rin. Kasi instead of si Pogi ang may obligation, ngayon yung bagong debtor is si Beauty na. Okay? So, that is mixed novation. So, ano nga ba yung requisites ng novation? Para mas malinaw. In novation, there are actually 4 essential requisites. Ano-ano sila? Namely, ito. First, tandaan nyo, dapat meron munang existence of a previous valid obligation. Okay? If yung original obligation is void, then there is nothing to novate. Diba? Tapos, second requisites, the intention and capacity of the parties to extinguish or modify the obligation. So, yung capacity and consent ng both parties ay indispensable requirements. So, third requisites, the extinguishment or modification of the obligation. Of course, dapat talaga magkaroon ng extinguishment noong previous or yung original obligation. Kasi nga, extinguishment of obligation nga din naman tong novation. So, for a valid novation, dapat meron ding extinguishment or modification ng obligation. And fourth, yung creation or birth ng valid new obligation. Okay? Dapat valid yung bagong obligation. So, again, memorize nyo itong apat or at least familiarize. First, dapat merong nag-exist. Okay? First is yung existence muna ng previous valid obligation. Second, dapat yung intention and capacity ng parties is to extinguish or modify the obligation. And third, the extinguishment mismo ng obligation, ng original obligation. And fourth is yung creation ng bagong valid obligation. So, Article 1292. In order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and the new obligations be on every point incompatible with each other. So, this is about express or implied novation. Pag sinabi mong express, eto siya. It be so declared in unequivocal terms. Yes. So, the new obligation expressly declares na yung old obligation ay mai-extinguish and magsa-subject into novation, and so magkakaroon ng bagong obligation either in the person of the debtor or on the magkakaroon ng bagong object Eto example. Si Pogi owes Ganda 500,000 pesos. Tapos evidenced by a promissory note. Later, nangutang ulit si Pogi kay Ganda ng worth 500,000 ulit. And by express agreement ng dalawa, they consolidated yung dalawang utang into one promissory note. So, instead of issuing another promissory note for 500,000 pesos, nag-issue na lang si Pogi ng 1 million pesos worth na promissory note, stating na itong second promissory note was to take place yung original or yung old promissory note that was earlier issued. Okay? So, mas madali itong express novation kaysa sa implied. Kasi nga, titignan mo lang if may express declaration ba. So, now, let's discuss implied novation. Sabi, according to Article 1292, ito, pag daw yung old and the new obligations be on every point incompatible with each other. So, simply put, yung implied novation is done by making substantial changes, either in the object or the subject matter of the contract. So, a good example of this is pag halimbawa yung isang obligation is before conditional, tapos later on, na tinanggal nyo na yung condition, naging absolute obligation na siya na magbabayad halimbawa ng 1 million pesos. So, in that sense, although hindi expressly but impliedly, nagkaroon ng novation kasi both obligation, yung may condition at saka yung walang obligation, kung tutuusin ay really incompatible with each other, right? Okay, malinaw ba? Sana naman. Now, eto yung mas maganda. Let's discuss kung ano-anong instances ba wherein the court has held that there was no extinctive novation. Sa mga instances na to daw ay walang novation, meaning they are not or they are compatible with each other naman. So, hindi talaga nagkaroon ng extinction at dahil hindi nagkaroon ng extinction ng previous obligation, meaning walang novation. Okay? So, pag walang novation, yung original contract remains. At ang sabi, ito daw ay modificatory novation lang. So, hindi extinctive. Number 1, pag daw merely yung new obligation merely clarified the total sum owed by the would-be buyer to the would-be seller, with the view that the former would find it easier to comply with his obligation under the contract to sell. Yan. So, obviously, kasi clarificatory lang, kinlarify lang kung ano ba talaga yung total sum na babayaran ni buyer sa kay seller. And as you can see, yung intention pa nga is para sa kay buyer na mas madali, para for an easier compliance dun sa kanyang obligation to easily complied, di ba? Another example, if yung change daw is consist only in time or place of payment, or in the mode or manner of payment, or yung rates of interest. Yun, yung mga ganun lang yung changes. Hindi siya novation. Nag-change lang ng time or place ng payment. So, more on, nag-modify lang pero they are not totally incompatible with each other. So, wala namang novation or extinctive novation. Wala daw. Third scenario, sabi ko, when the new contract merely contains supplementary agreement. Oo, sinusupplement niya lang, in short. Hindi sila nga incompatible. Fourth, when additional security is given. Oo, hindi daw yung novation, sabi nila. Ay sabi ni court. And then, fifth example is kung yung public instrument is executed to confirm a valid contract. So, nag-execute nga ng public instrument, pero that is to confirm a valid contract. And then, yung last example, if yung mere extension of term lang or period of payment or performance. Yun yung mga instances kung saan sabi ng court na walang extinctive novation Kung hindi, yun daw ay mga more on modification lang. So, that's it. Ano pa ba? Wala na ata. Let's proceed to Article 1293. Novation, which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Payment by the new debtor gives him the rights mentioned in Article 1236 and 1237. Okay, so let's discuss personal or subjective novation. Ito yung isang kind ng obligation na yun nga, yung change is yung person ni debtor. Now, actually, merong dalawang kinds ng personal or subjective novation. Pag change of debtor, meaning passive, that is substitution. When you say change of creditor, meaning active, so subrogation. Eto pala, baka naman until now, hindi nyo pa alam sino ang passive at active subject ng obligation. So, remember, yung discussion natin sa elements of obligations, si passive subject ay si debtor or obligor. And yung active is si creditor. Ano nga ba yung rationale nun? Sabi ko, di ba? Si creditor, siya yung active subject kasi siya yung may right to demand to demand payment or to demand fulfillment ng obligation. Kaya siya yung active subject. Okay? So, Article 1293 actually talks about passive subjective novation. Passive kasi sa on the part of the debtor to. So, substitution on the part ni debtor. Okay? And it could be in the form of expromission or delegation. Now, let's discuss first expromission. Expromission, pag ang initiative daw comes from a third person. So, dito, dapat, yung initiative for a change of a new or substitution ng debtor comes from a third person. So, dapat talaga yung original or yung old debtor ay ma-released from his obligation. Kasi pag hindi, walang obligation. So, ganito, example. Pogi owes Ganda 10,000 pesos and it is due on, say, December 25. Tapos, si Beauty goes to Ganda at sinabi niya, i-assume niya yung obligation ni Pogi to pay Ganda 10,000 pesos. Sabi niya, ako nang magbabayad sa utang ni Pogi, consider me your new debtor. Hindi na si Pogi. Pogi is to be excused or released from his obligation. Do you agree? Sabi ni Beauty kay Ganda. Sagot naman ni Ganda, okay, no problem. You are now my new debtor. Hindi na si Pogi. So, in this example, is the obligation extinguished? Yes, di ba? Because Ganda consented to the novation. Now, supposing Beauty becomes insolvent, okay? Can Ganda proceed against Pogi to collect the 10,000 pesos? Hindi na, kasi nagkaroon na nga ng novation. Sabi nga Pogi is to be excused released na nga siya sa kanyang obligation at inaccept ni Ganda yon. So, the moment the creditor consented to the novation, the obligation is totally extinguished. Na-extinguish yung obligation ni Pogi, nagkaroon ng bagong obligation. Okay? Sakay Beauty to Ganda. Ito pala yung requisites ng expromission. Ito first, the initiative must come from a third person. So, in our example, from Pogi, siya yung lumapit kay Ganda. Second, the new debtor and creditor must consent. Diba? Nagkasundo, sabi ni Beauty, do you agree? At sabi ni Ganda, yes. Okay. So, and third requisites, the old debtor must be released from his obligation. Diba, sabi nga, ako na, released na, excuse na si Pogi, I will be your new debtor. So, yun. Kompleto yung tatlong requisites. Tandaan nyo yun. Para hindi kayo maguluhan kung meron bang expromission or wala. Okay? And note din pala under Article 1293, yung old or original debtor, eto tandaan nyo, hindi niya kailangan ng consent, 'di ba? Nakita niyo sa example, hindi nagbigay ng consent si Pogi, pero nagkaroon ng novation. Kasi yung sinasabi lang naman ni Article 1293, kung babasahin natin, ay may be made even without the knowledge or against the will of the latter. So kahit against the will daw ni debtor, but not without the consent of the creditor. So ang importante is yung consent ni ganda sa example natin. Consent ni creditor, hindi kailangan o kahit pa nga daw against the will ni debtor. Now, bago natin i-discuss yung last sentence ni Article 1293, compare muna natin si delegation expromission from delegation. Pag delegation naman, ito naman yung substitution pa rin nung person ni debtor, pero yung initiative or comes from the debtor himself, siya mismo. Kasi yung expromission from a third person, pag delegation, yung initiative comes from the debtor. Kaya nga delegasyon, di ba? Siya ang nagde-delegate sa ibang tao to pay the debt or the obligation and excuses himself, di ba? In return, dahil nag-introduce siya ng ibang tao to pay his obligation, he will be released from the obligation to pay or to fulfill that obligation. Nagets nyo? Anyway, same with expromission, dapat sa delegasyon, pareho lang kasi novation lang naman din yung dalawa, si old debtor must be released from the obligation. Otherwise, walang valid na delegasyon, walang novation. Di ba kay expromission, dapat doon talaga malinaw na may re-released si old debtor sa obligation. Dito, yun din, dapat malinaw si old debtor, he must be released from the obligation. Pero dito kay delegasyon, we had three parties, si old debtor, si new debtor, and si creditor. And dapat silang tatlo mag-agree. Okay? Mag-agree to the novation para maging valid yung novation. Para maging valid si delegasyon. Okay? Halimbawa, ganito. Si Pogi, sinabihan niya, doon pa rin sa example kanina, sinabihan niya si Ganda na si Beauty na ang magbabayad ng kanyang utang. And so, si Ganda ay pumayag. Nung pumayag si Ganda, by the time na pumayag si Ganda, na si Beauty na ang magbabayad ng utang ni Pogi, it does not necessarily mean na kaagad na there is a delegation. Okay? Kasi, pumayag pa lang naman siya na si Beauty ang magbabayad sa kanya. Pero kung yung nangyari is ganito, nung sinabi ni Beauty na nung sinabi ni Pogi na si Beauty na ang magbabayad, and hiningi niya kay Ganda that he be released from his obligation, okay? Na ma-release na siya sa kanyang obligasyon, wala na siyang obligasyon, si Beauty na ang may obligasyon, and to that premise ay pumayag. Doon nag-agree si Ganda. Then, in that case, nagkaroon ng delegasyon. Okay? Nagkaroon ng novation. Kasi yung four requisites ng novation ay present. Pero, ano din ba yung requisites for a valid delegation? Siyempre, lahat ng nasa novation, present naman yun. Tapos, eto pa pag sa delegasyon. Dapat pag delegasyon, yung initiative comes from the old debtor. And second, lahat ng parties must consent or agree. Pag sinabing lahat, si debtor, si old debtor, si new debtor, and si creditor. They must agree or they must consent to the delegation. And dapat, di ba, sabi ko nga pabalik-balik na dapat ma-release si the old debtor sa kanyang obligation na kung saan i-assume ni second debtor or yung new debtor. Now, let's proceed to the last sentence ng Article 1293. sabi, di ba, payment by the new debtor gives him the rights mentioned in Article 1236 and 1237. Di ba, naalala niyo ba yung beneficial reimbursement tsaka subrogation? Anyway, ang ibig sabihin nito, if si new debtor daw, if siya ay nagbayad kay creditor, siya ay magkakaroon ng rights mentioned under 1236 and 1237. If you are to read 1236 and 1237 again, ang ibig sabihin nun is beneficial reimbursement. Magkakaroon si new debtor ng beneficial reimbursement if yung payment ay ginawa ng walang knowledge or against the will ni old debtor. And magkakaroon siya ng additional right, di ba, hindi lang reimbursement but kasama yung subrogation if it was made with the consent ni old debtor. Right? So, wag niyong kalimutan yung mga previously na-discuss natin na topic kasi mga related lang naman lahat-lahat ng provisions na to. The way to study obligation and contracts is not to just memorize. Kailangan mo mag-imagine and to look at it outside the box. Anyway, in both cases, kang expromission and kay delegation, what is consistent is yung consent ni creditor. Diba? Kay expromission, kahit walang consent ni debtor, kang delegation, malamang meron kasi siya yung may initiative. Pero in both cases, kailangan yung consent ni creditor. So that is actually an indispensable requirement rin. Okay? Bakit? Bakit kailangan ng consent ni creditor in all cases or in both situations? Kasi in the first place, yung substitution may be prejudicial to the creditor, di ba? Pwedeng magkaroon ng delay in the fulfillment of the obligation, pwedeng magkaroon ng contravention or yung non-performance talaga ng new debtor to pay. Hindi naman siya on the first place yung original debtor talaga. It is also consistent with the rule that a creditor cannot be compelled to accept payment or performance by a third person who has no interest in the fulfillment of the obligation. Yan, nasabi ko na rin ata yan before. Okay? So, Article 1294 na tayo. If the substitution is without the knowledge or against the will of the debtor, the new debtor's insolvency or non-fulfillment of the obligations shall not give rise to any liability on the part of the original debtor. So this provision talks about the effect of insolvency or non-fulfillment by the new debtor in expromission. Okay, expromission to kasi pag binasa mo, substitution without the knowledge or against the will ni debtor. So meaning, yun yung expromission. So ano nga ba ang epekto ng insolvency ni new debtor? After niyang na inassume yung obligation ni old debtor. So, under Article 1294, sabi, the new debtor's insolvency or non-fulfillment of the obligation will not revive the action of the creditor against the old debtor. Okay? Kasi di ba nga, the old debtor was already released from his obligation. Yun yung mahalaga, isa sa mga requirements para magkaroon ng valid expromission. Sabi ko kanina, kailangan yung previous obligation, yung old debtor must be released from his obligation. So yung previous obligation is extinguished by the assumption of the debt by the new debtor. And so, if yung new debtor later on hindi makapagbayad, hindi na pwedeng maningil ulit si creditor kay old debtor. After all, expromission was actually without his consent. Walang consent si old debtor doon. Pumayag si creditor. Right? That is Article 1294. Let's discuss muna Article 1295. Kasi halos magkarugtong lang din sila ni Article 1294. Okay? Eto si Article 1295 naman. The insolvency of the new debtor, who has been proposed by the original debtor and accepted by the creditor, shall not revive the action of the latter against the original debt obligor, except when said insolvency was already existing and of public knowledge or known to the debtor. Okay, so dito naman, kay Article 1295, It talks on the effect of insolvency by new debtor in delegasyon. Kasi diba si 1294 ay nagdi-deal with the effect ng insolvency or non-fulfillment by the new debtor in expromission. So, eto is sa delegasyon. Ano nga ba yung epekto ng insolvency or ng non-fulfillment ng new debtor? Anyway, the first thing that you will notice dito sa 1295 is this provision deals only with insolvency. Unlike kay Article 1294 na insolvency and non-fulfillment. Kay Article 1295, insolvency lang. Hindi kasama ang iba pang causes ng non-fulfillment. And this provision provides for a requisites in order to hold the old debtor liable. Kasi nga, di ba, sabi, the insolvency of the new debtor who has been proposed by the original debtor and accepted by the creditor. So, delegasyon nga ang tinutukoy dito, right? Ang sabi pa, it shall not revive the action of the latter against the original obligor. So, yun talaga yung general rule. Same with actually Article 1294, yung insolvency or yung non-fulfillment ni new debtor, hindi na magre-revive ang obligation ni old or original debtor. Okay? Pero dito kay 1295, may karugtong. Sabi niya, except when said insolvency was already existing and of public knowledge or known to the debtor when he delegated his debt. So, eto. Number 1, insolvency was already existing and of public knowledge at the time of the delegation. So, yun yung unang exception kung saan kahit pa na-extinguish na nga sana, di ba? And the general rule is hindi na ma-revive yung obligation ni original debtor or ni old debtor. Pero pag yung scenario is yung insolvency daw ni new debtor was actually already existing and of public knowledge at the time ng delegation, then that is the first scenario wherein si old obligor will still be liable, okay? Although it was not known to the old debtor dito sa first scenario. Kahit pa hindi alam ni debtor na insolvent na yung kanyang dinidelegate, yung taong dinidelegatean niya ng obligation, pero kasi yung insolvency was already existing and of public knowledge na actually. Tapos yung second scenario or case, under Article 1295 is when the insolvency was already existing and known to the debtor at the time of the delegation. So, dito, hindi naman public knowledge, pero alam ni debtor. Alam niya na by that time, ay insolvent na yung taong yun. Pero sa kanya pa rin, nag-delegate pa rin siya, binigay niya pa rin sa kanya yung obligation to pay his creditors. Okay? So, notice na if the insolvency ni debtor or ni new debtor ay nangyari lang after ng delegation, hindi na talaga magiging liable pa si old or original debtor. Basta tandaan lang na sa case or sa situation na to, if alam ni debtor or if hindi niya alam pero of public knowledge na insolvent yung tao na yon, and yet the debtor or the old debtor still delegates the obligation to that insolvent person, magiging liable pa rin si old debtor. Okay? Actually, these exceptions is intended to prevent fraud on the part of the old debtor, 'di ba? Kasi parang magiging escape sa obligation. Anyway, let's take an example. Pogi owes Ganda 1 million pesos. Tapos, etong si Pogi, nag-propose siya kay Ganda na si Beauty will substitute him as a debtor. Okay? Tapos si Ganda agreed to the proposal. Nag-agree siya. Now, if at the time of the delegation, Beauty was already insolvent, But yung insolvency ni Beauty was neither of public knowledge at hindi rin alam ni Pogi. So, in this case, Pogi will not be liable. Okay? Kasi wala siya sa exception. Di ba? Hindi siya nung public knowledge, yung first scenario na diniscuss natin kanina, and hindi din alam ni debtor. So, wala siya sa dalawang exception. So, yung general rule ang mag-a-apply, which is, ang sabi, hindi na daw mare-revive yung original obligation ni debtor. All the more pa nga if yung insolvency ni Beauty, in this example, ay nangyari after na nung delegation. After nang ma-delegate ni Pogi ang kanyang utang kay Beauty. Okay? That's it. Let's proceed to Article 1296. When the principal obligation is extinguished, in consequence of a novation, the accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. So, 1296 or this provision talks about the effect of novation on accessory obligations. Okay? Pag daw yung principal obligation ay na-extinguish by novation, yung accessory obligation will subsist only insofar as they may benefit third persons who did not give their consent. So, meaning, kasi sabi may subsist only, so generally, applicable pa rin yung general rule na extinguishment of the principal obligation carries with it that of the accessory obligations, di ba? Pag nawala si principal obligation, susunod din doon si accessory obligations. Yun yung general rule. Pero, sabi ni Article 1296, accessory obligations may subsist only. So, ito ay nagbibigay ng exception na, sabi pa nga, only insofar as they may benefit third persons who did not give their consent. So, that is Article 1296. Ganito yung kanyang halimbawa. Si Ganda, Pogi, may utang kay Ganda. Say, sabihin natin 1 million naman. 1 million pesos. Tapos, meron siyang guarantor. So, ang guarantor niya ay si Beauty. Okay, guarantor na dito si Beauty ngayon. Now, si Pogi is substituted by, say, sino ba? By Makisig, okay? So, nagkaroon ng novation, si Pogi is released from his obligation. Si Makisig na ngayon ang may obligasyon na magbigay ng 1 million pesos kay Ganda. So, dahil nagkaroon ng novation under Article 1296, etong si Beauty na guarantor ni Pogi will also be released from his or from her obligations. Kasi nga, she only guarantees Pogi's performance ng obligation niya kay Ganda. Kasi naman, baka yung credit standing ni Pogi ay maganda, pero yung kay Makisig ay pangit, ay ayaw ko rin maging guarantor niya. Anyway, pero at Article 1296, sinabi niya mismo na si principal obligation, pag na-extinguish, mawawala din si accessory obligation. Although may exception. Now, magbigay tayo ng example ng exception. Ito. Si Bogie may utang kay Ganda nga na 1 million pesos with, say, an interest of 12%. Okay? Tapos, nasa usapan nila na yung interest na 12% ay ibibigay ni Pogi kay Beauty. Now, later, itong si Pogi at Ganda ay nagkasundo na instead of paying the 1 million pesos na utang, ibibigay na lang ni Pogi ang kanyang sasakyan kay Ganda. So, in this example, di ba, na-extinguish yung original obligation which is to pay 1 million pesos dahil nagkaroon ng novation, change of object naman ito. Pero yung 12% interest, sabi dun sa accessory obligation, yung 12% interest ay ibibigay ni Pogi kay Beauty, di ba? Based doon sa original na obligation. ito ay hindi na extinguished. Magsasubsist siya according kay Article 1296. Kasi nga, sabi, magsasubsist daw insofar as they may benefit third persons who did not give their consent. So, unless si Beauty ay nag-consent doon sa novation na ang ibibigay na lang ni Pogi kay Ganda ay yung sasakyan niya. So, mawawala din yung 12% interest na ibibigay sana kay Beauty. Pero kung without the consent of Beauty, di kahit pa ibigay ni Pogi yung kanyang sasakyan as payment na kay Ganda, in replacement or is a substitute doon sa original obligation nila, magiging liable pa rin siya, magsasubsist yung 12% interest na accessory obligation which is ibibigay niya kay Beauty. Right? Now, Article 1297. If the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. So, ito ay ang effect if the new obligation is void. Alam nyo, this provision really stresses the one of the essential requisites of a valid novation. Alam niyo yun, alala nyo yung diniscuss natin kaninang 4? Diba yung last doon is dapat yung new obligation must be valid. Well, yung tamang term ata na ginamit is yung fourth requisite is yung creation or birth of a valid new obligation. Diba? So, what is the effect if yung pang-apat or yung creation ng bagong obligation is actually not valid? Void pala yung bagong obligation. Yan yung dinidiscuss ni Article 1297. Ang sabi ni Article 1297, the original shall subsist. Diba? Kung tutuusin, dahil yung new obligation is void, hindi valid, meaning there is no novation, di ba? Kasi isa siya sa mga requisites for a valid novation. And absent siya. So, of course, obviously, the result would be yung old obligation ay hindi na extinguish or wala kasing novation pala talaga na nangyari. So, yung old obligation subsist. Right? Nagets nyo ba yung sinasabi ko, yung explanation ko? Yun lang. Kasi nga hindi valid yung bagong obligation. Fourth requisites, creation of a new valid obligation. So, eto, hindi valid pala yung new obligation, void pala siya. So, magsasubsist ngayon si old obligation. Yung original obligation shall subsist for the reason that the second obligation is inexistent or it cannot extinguish or modify the first obligation being void. So, paano naman if hindi void? Kung hindi voidable lang, what do you think? I mean, yung bagong obligation is voidable lang. Diba? As nasabi ko na rin before, yung voidable obligation is actually, or voidable contract, yung mga voidable debts, ganyan, they are valid until annulled. So, yung old obligation is still novated dahil voidable obligation is still valid until it is annulled. But, by the time that it is annulled, kung na-declare na nga siya na void, so the novation must be considered as not having taken place. Okay? But Article 1297 also provides for an exception. Karugtong lang naman din nung binabasa natin. Sabi, so what is the exception to the rule that there is no novation if the new obligation is void? Pag ganyan yung tanong, ang sagot nyo, sabi ni Article 1297, unless the parties intended that the former relation should be extinguished in any event. Okay? Yung intention talaga ng party is to extinguish in any event yung old obligation. So, hindi na siya magsasubsist. Now, Article 1298. The novation is void if the original obligation was void, except when when annulment may be claimed only by the debtor or when rectification validates acts which are voidable. So this article has its basis also on the requisites of a valid novation. Same with 1297, di ba? Naka-base siya dun sa requisites for a valid novation. Ito naman, oo, di ba? Kasi one of the requisites for a valid novation, kung naalala nyo yung first, dapat mayroong existence of a previous valid obligation. So, si Article 1298 talks about a situation kung saan yung old obligation was void pala. Okay? So, ano daw ang mangyayari? Sabi, if the old obligation is void, then there is no valid novation. Bakit? Aba, tinatanong pa ba yun? Anyway, obviously, kasi nga void yun. Kulang ng requisites, walang novation. Walang pre-existing obligation. Walang pre-existing, valid obligation. So, what's there to novate, di ba? There is nothing to novate in the first place. So, example ganito. Example muna tayo. Si Pogi, inoblige niya yung sarili niya to deliver to Ganda, say, an illegal drugs. Okay? Tapos later on, nagkasundo tong dalawa, si Pogi at si Ganda, na instead of delivering that illegal drugs like 1 kilo shabu, ganyan, si Pogi ay magbibigay na lang ng pera, which is 10,000 pesos, sabihin natin. So, dito, there is no novation. Kasi yung pagbibigay ng 1 kilo shabu to Ganda is void. It is a void obligation. So, wala talagang original obligation that is in existence. Inexistent. So, there is nothing to change or to novate. Right? Pero, if the original obligation is voidable only, hindi naman talaga void, okay, a valid novation can take place because voidable contracts ulit are valid until annulled by proper action in court. So, example, if si Ganda, he was just forced by Pogi or through fraud kaya na nag-execute si Ganda ng promissory note worth 10,000 pesos in favor of Pogi, which is payable on December 25. However, after nung fraud, etong si Pogi and si Ganda, nag-novate sila, okay? They make a change to their previous agreement or transaction such that instead of giving daw 10,000 pesos, si Ganda will just give Pogi a specific car. Okay? Now, dito, yung obligation ni Pogi to give Ganda a specific car is valid because the first obligation is only voidable, valid until annulled by action in court. Since hindi naman nila dineclare or wala namang action before the court to annul, hindi na annulled yung previous obligation, so pwede pa. Okay? Pwedeng magkaroon ng valid novation. Okay? Now, Article 1299. If the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition unless it is otherwise stipulated. So, etong provision na to talks about the effect if the original obligation was conditional. So, general rule, yung condition, kasi naka-attach naman talaga siya sa original obligation. So, yung conditions attached to that old obligation will also be attached to the new obligation. Magkakaroon pa rin ng condition yung new obligation. Now, ano yung exception? Pag daw merong contrary stipulations. Okay? So, let's take an example. Ganito. Pogi promised Ganda to deliver a car. if Ganda will pass her board examinations. Tapos later on, yung dalawa, nagkasundo sila na instead of giving the car or a car, ay iba na lang yung house and lot na lang daw ang ibibigay ni Pogi kay Ganda. Kasi mayaman si Pogi, di ba? Now, dun sa bagong usapan, walang na-mention, dun sa second contract, walang na-mention about the condition. So, ang question, is the new obligation also subject to a suspensive condition? So, the answer is yes. Kasi, unless it was otherwise stipulated in the new contract na wala na talaga si condition, the delivery of a house and lot would therefore be due only after Ganda passed the board exam or her board exam. Okay? Tapos, yan din naman yung sabi ni Article 1299. Di ba nga, pag binasa mo, if the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition unless it is otherwise stipulated. So, kung hindi na mention na mawawala na yung condition, bibigay na talaga ni Pogi no matter what, pumasa o hindi man si Ganda ng board exam, bibigay niya yung house and lot, di okay, pwede naman. Pero pag walang na-mention about that, yung presumption ng batas or sinasabi ni Article 1299, magiging subject pa rin sa suspensive condition. Depende kung suspensive or resolutory condition yung ginawa. In our example, that is suspensive condition. Okay? So, that's it. Let's proceed to Article 1300s. Eto, ibang topic na. I mean, yung third scenarios na tayo. Yung sa subrogating a third person in the rights of the creditor. So, Article 1300s. Subrogation of a third person in the rights of the creditor is either legal or conventional. The former is not presumed, except in cases expressly mentioned in this code. The latter must be clearly established in order that it may take effect. So that is Article 1300s. Well, obviously, 1300s, yung provision na to ay discusses more on subrogation. And I think na-discuss na natin pabalik-balik yung subrogation before. Anyway, just to define in passing, kung gusto nyo maintindihan pa, ano na lang, nandun na na-discuss. I doubt if hindi nyo pa naiintindihan as of now. Pero subrogation is, as defined, is the transfer to a third person of all the rights pertaining to the creditor, including yung rights to proceed against guarantors, possessors of mortgages. Through subrogation, a person is put into the shoes of the creditor, and so pwede niyang gamitin or nakuha niya pati yung right to proceed against guarantors, possessors of mortgages, yun, yung mga ganun. Anyway, si Article 1300 also talks about the two kinds of subrogation. Sabi, legal or conventional. When you say legal daw, dapat, sabi, the former is not presumed. So, yung legal subrogation is not presumed. Meaning, kailangan talaga expressly provided. Merong batas na nagsasabi na ito ay may subrogation. Okay? Tapos, ano naman daw, conventional subrogation ay dapat daw must be clearly established in order that it may take effect. So, kailangan naman clearly established siya. Anyway, proceed na tayo kay Article 1301. Kasi itong 1301, it discusses on conventional subrogation. Okay? Eto, 1301, conventional subrogation of a third person requires the consent of the original parties and of the third person. So, eto, sabi ni Article 1301, consent of all the parties are required in conventional subrogation. Yun lang naman yung ibig sabihin pag binasa mo, di ba? So, di ba, is Conventional meaning by agreement of the parties. So, dahil nga by agreement, so kailangan yung consent ng lahat, original parties, meaning si old debtor at si creditor, and then yung third person, yung magiging new debtor. So, kailangan may agreement or may consent silang tatlo. Yun yung Article 1301. Now, let's proceed to Article 1302. Sabi, it is presumed that there is a legal subrogation, one, when a creditor pays another creditor who is preferred, even without the debtor's knowledge. Second, when a third person not interested in the obligation pays with the express or tacit approval of the debtor. And third, when even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. So, that is Article 1302. Ito yung mga cases or instances kung saan merong legal subrogation. Okay, so let's begin or let's start with the first instance ng legal subrogation according kay Article 1302. Sabi, when a creditor pays another creditor who is preferred even without the debtor's knowledge. So, mas maganda may example. So, example na tayo. Ito. Pogi owes Beauty and Ganda. Meron siyang utang kay Beauty and kay Ganda. Halimbawa, yung utang niya kay Beauty is may mortgage, okay? Secured by a mortgage worth 1 million pesos. And then, yung utang niya kay Ganda is, sabi natin 500,000 pesos. Tapos, Ganda is just an ordinary creditor. Hindi, walang security. So, if ang ginawa ni Ganda without without Pogi's knowledge, kasi sabi naman even without the debtor's knowledge. So kung granting walang knowledge si Pogi, si Ganda, binayaran niya si Beauty ng 1 million pesos, which is yung utang ni Pogi kay Beauty. So dito, si Ganda will be subrogated in the rights of Beauty. Meaning, si Ganda ngayon ay mayroon ng or naging mortgage creditor na siya, hindi na lang siya ordinary creditor. As to that 1 million pesos. Pero as to the 500,000 pesos na utang ni Pogi sa kanya, she is just an ordinary creditor pa rin naman. Now, if Pogi fails to pay the 1 million pesos na debt kay Ganda, so Ganda can have the mortgage foreclosed. That is yung, pwede nyo ma-foreclose yung property kasi nga naging mortgage creditor na siya, di ba? He or she was subrogated to the rights of Beauty nung binayaran niya si Beauty ng 1 million pesos. So, yun yung example ni Article 1302, first paragraph or number 1 na scenario or case. Now, the answer will actually be the same kung si Ganda ay nagbayad kay Beauty with the knowledge of Pogi. Pareho lang. Kasi sinabi lang naman is even without the knowledge of the debtor. So, whether may knowledge or wala, pareho lang. Masosobrogate, magkakaroon pa rin ng subrogation. Okay? Now, dito naman sa second scenario, pag daw yung third person not interested in the obligation pays with the express or tacit approval of the debtor. Yan yung sabi, di ba? Ang example dito is ito. If si Pogi may utang siya kay Ganda na 10,000 pesos which is due on December 25, tapos etong si Beauty, pumunta siya kay Ganda, nagbayad siya ng 10,000 pesos with the consent of Pogi. So, dito, si Beauty is subrogated to the right of Ganda. So that if the debt is secured by a mortgage property, si Beauty, she can foreclose the mortgage if si Pogi ay hindi makapag-reimburse kay Beauty. However, kung yung pagbabayad ni Beauty kay Ganda ng 10,000 pesos was without the consent of Pogi. So, Beauty cannot foreclose the mortgage property because dito walang legal subrogation. Klaro kasi sa number 2, pag binasa mo yung provision mismo ni Article 1302, di ba? With the express approval of the debtor. So, meaning, kailangan yung approval ni debtor para magkaroon ng subrogation or legal subrogation. So, kung walang knowledge, hindi alam ni Pogi na nagbayad si Beauty kay Ganda, wala siyang right to subrogation. Ano lang yung meron sa kanya? Yes, yung sa na-discuss natin sa payment before, kung mako-correlate mo siya dito, only beneficial reimbursement. Kung magkano lang yung na-reimbursed. Diba? Ganun. I-correlate nyo yung mga provisions para mas gumaling kayong mag-answer ng mga problems. Now, eto naman sa third scenario. When even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. Eto ha, even without the knowledge daw ni debtor. Si person interested, sino ba yung mga person interested? Alam na natin to, di ba? Yung mga guarantors, yung mga, of course, mismong yung owner ng property na mortgage, ganun. Yung may mga interest doon sa payment ng utang. So, ganito, example. If si Pogi, may utang siya kay Ganda na 10,000 pesos nga, eto is secured by a mortgage and guaranteed by, sabihin natin, ginaranty ni Beauty. Okay, guarantor dito si Beauty. Now, if si Beauty, binayaran niya si Ganda, even without the knowledge of Pogi, ha? Hindi alam ni Pogi, binayaran ni Beauty si Ganda ng 10,000 pesos. Then, by that alone, siya ay na-subrogate to all the rights of Ganda. Because as a guarantor, he is interested, she is interested in the payment of the obligation, right? Dahil interested siya sa fulfillment ng obligation, nung binayaran niya si creditor, which is in the person of Ganda, automatically nagkaroon ng legal subrogation even without the knowledge ni debtor. Yun yung ibig sabihin ng third scenario. Now, eto namang sinabing without prejudice to the effects of confusion as to the latter share, meaning kasi 'di ba si Beauty is a guarantor or 'di ba? So, ang ibig sabihin niyan, yung legal subrogation ay dahil sa pagbayad ng binayaran ni Beauty si Ganda at nagkaroon ng legal subrogation, yung guarantee ay na-extinguished. Okay? Kasi after all, siya naman yung guarantor. Alangan naman mag-claim siya sa sarili niya ng kapag hindi makapagbayad si Pogi, singilin niya yung sarili niya kasi siya yung guarantor. So, may extinguish yung guarantee na dahil nga sa confusion. However, since yung example natin is, other than yun nga may guarantee, ay secured pa rin ng mortgage. So, since nagkaroon ng legal subrogation, na-acquire niya nga lahat ng rights na meron si creditor, then, pwede niya pa rin i-foreclose yung property. Pero hindi na siya pwedeng mag-proceed against the guarantor kasi siya nga yung guarantor. Nagkaroon ng confusion as to the guarantee. Okay? So, na-extinguish na wala yun. Yun yung ibig sabihin ng without prejudice to the effects of confusion as to the latter's share. So, yun. Okay? So, Article 1303. Subrogation transfers to the person subrogated the credit with all the rights thereto appertaining either against the debtor or against third persons, be they guarantors or possessors of mortgages, subject to stipulation in a conventional of subrogation. Okay, so what are the effects of subrogation? Yun yung tanong na sinasagot ni Article 1303. Sabi, subrogation transfers to the person subrogated the credit with all the rights appertaining thereto. So, either against the debtor or against third persons. be they guarantors or possessors of mortgages subject to stipulation and conventional subrogation. So, yun nga. Binasa ko lang din ulit. Anyway, let's take an example. Ganito, para mas maintindihan. Kasi parang ayoko na mag-explain. Masyado naman siyang halata. Or pabalik-balik na ba? Pabalik-balik na yung concept. So, example na lang din tayo. An example, Pogi owes Ganda 10,000 pesos, tapos si Beauty nga yung guarantor. Now, if third person, say, Makisig, paid Ganda 10,000 pesos, tapos with the consent of, Pogi and Beauty. Pogi and Ganda. Si Ganda kasi yung creditor. So, dahil doon, si Makisig now is subrogated in the place of Ganda. So that if Pogi cannot pay Makisig 10,000 pesos as reimbursement, si Makisig can proceed against yung guarantor, which is Beauty. Pwede niyang singilin si Beauty. Dahil nga, siya ay na-subrogate. So, yun yung effect ng subrogation. In the same example, if there is no guarantor but there is a property mortgage to, halimbawa, to Ganda, then si Makisig, if hindi makapagbayad si Pogi, Makisig has the right to foreclose the mortgage property. Kasi nga, after all, si Pogi consented to the payment and there is a legal subrogation. So, yun yung effect ng legal subrogation. Pabalik-balik na tayo. The third person is put into the shoes of that creditor at he acquires all the rights na nasa kay creditor. So, yun yung ibig sabihin or ang epekto ng subrogation. Now, punta na tayo kay last provision para sa novation. Ito is Article 1304. A creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. So, eto is partial subrogation. Meron ding partial subrogation, hindi lang total palagi. Okay? Ang sabi, there are two creditors. Meron tayong old creditor who still remains a creditor as to the balance. Kasi nga, may partial payment na, pero hindi pa nga, partial payment, hindi pa nababayaran ang buo. So, as to the remainder, siya ay creditor pa. Tapos, meron ng new creditor who is a creditor to the extent of what he had paid to the creditor. Ano ba? Naintindihan nyo ba? Or mas magulo? Anyway, ganito siya. Ganito. If etong si Pogi may utang siya kay Ganda na, say, 1 million pesos. Tapos, with the consent ng dalawa, Pogi at Ganda, etong si Beauty, binayaran niya si Ganda ng 500,000 pesos lang. Kasi yun lang yung pera niya. So, meron pang 500,000 pesos na remaining balance. Now, if si Ganda and si Beauty, silang dalawa na ngayon ay naging creditors ni Pogi, di ba? To the amount of 500,000 pesos each. Kasi binayaran ni Beauty si Ganda. So, nagkaroon ulit ng utang si Pogi kay Beauty na 500,000 pesos at may utang pa rin siya kay Ganda na 500,000 pesos. Yung remaining balance. So, supposed, etong si Pogi ay meron na lang 500,000 pesos na pangbayad. Ang tanong, kanino niya ibabayad? Who is preferred? Ang sagot is Article 1304. Ang sabi, kay Ganda. Kasi daw, yung original creditor should be preferred in as much as he is granted by law preferential right to recover the remainder. Okay? So, dahil sa right of the remainder, magkakaroon ng mas preferred na right si original as to the remaining balance. Okay? That is Article 1304. And that ends our discussion sa novation, pati na rin actually sa extinguishment of obligation. So, good luck sa inyong lahat. Sana makapasa kayo if ever. Usually kasi coverage ng midterm exam hanggang dito. So, yes, good luck. Hopefully natulungan ko kayong lahat. And so, God bless!